Good day, everybody. Welcome to the Silver Therapeutics 2022 virtual expungement clinic recording with retired attorney Michael Cutler. Today is September 20th, 2022. Michael will be running through a PowerPoint presentation on the current updated laws. Michael, welcome. Let's get this started.
Thank you, Brian. I welcome people to this presentation on criminal record relief, public service by Silver Therapeutics. And I'm going to be explaining today how people with criminal records can seek relief, which is to say the removal of those records, those criminal records from public access, and also about how a criminal record works generally for people seeking employment or housing. And then lastly, I'm going to talk about how people with criminal records can enter the cannabis industry in particular. The outline of my talk is going to be talking about criminal record relief laws in general. I'm going to zero in on the act of sealing a criminal record, and next on the process for expunging a criminal record. I'm going to explain the difference between sealing and expunging. I'm going to talk about the process for doing so. I'm going to talk about general employment law with private employers for people with criminal records seeking jobs. And lastly, I'm going to talk about seeking employment in the cannabis industry or a license to own a cannabis facility under the Massachusetts, within the Massachusetts cannabis industry for people with criminal records. So, Brian, let's have the next slide. Okay. The purpose of these record relief laws is to protect both privacy and promote rehabilitation for former offenders. The purpose of removing a criminal record from public access is to improve a former offender's access to employment, housing, and professional licensing, which types of employment and housing can help deter recidivism. It's worth noting that in Massachusetts, which has more than 6 million citizens, there are nearly every 4 in 9, nearly 43% of people have prior criminal records. Even if the charges were dismissed or found not guilty, those criminal records will still be out there for people to see, and that in public court dockets or in the Office of Commissioner of Probation, who maintains criminal records. And there's a criminal offender record information agency that also oversees both the compilation of criminal records and access to those records. And and a criminal background check is a part of many employment processes, and it is required for people who want to get either a license to own a cannabis business in Massachusetts or to be employed by a Massachusetts cannabis businesses. So being able to remove a criminal record from public access will help you both generally in employment and housing and specifically in getting into the Massachusetts cannabis industry. Next slide, please. Okay. We're talking about removing access to a criminal record, and that's done one of two ways, either by sealing or expungement. Now, these are matters of state law and only pertain to state criminal records. Federal criminal records are not subject to relief under this sealing or expungement process. The only type of relief for a federal criminal record is for a clerical error or a presidential pardon. The other aspect of federal criminal record collection is that the FBI is the primary federal agency that scoops up state criminal records. Not every criminal record is picked up by the FBI, but the FBI picks up many criminal records. And even if the record has been sealed or expunged at the state level, it may still be in the federal FBI records, so that if an employer or a housing agency goes to the feds, which is not a frequent activity, but can happen, then the sealing or expungement at the state level will not necessarily protect you from the feds disclosing this criminal record. Uh, but people who have had their records either sealed or expunged can answer no arrests or no criminal convictions when faced with a housing or a job application. It gives you the ability to say no record and to do so lawfully after the sealing or the expungement has been ordered. Now, if you've got access to these slides, you'll see in several places I've put in a warning about people who have their records expunged or sealed. And that is, before you take this action, you should get a certified copy of all of the criminal records held by the trial court where you incurred the record, because once sealed or expunged, it's hard to get back to these original records. And if you have the original record certified copy after it's been sealed or expunged, and that record pops up despite being sealed or expunged, by having a copy of the record, you can show people that, well, this case was dismissed, or it happened 20 years ago. You can still provide information about that record if it pops up despite being sealed or expunged. So it's important to maintain these original records, and this is particularly important for people who have immigration issues, because particularly once you've expunged the record, it doesn't exist anymore. And if the feds pick it up, and the feds are the agency for immigration immigration dispositions, then having that certified copy of the original record that was expunged or sealed will help you defend an immigration matter. So it's important to keep an original record of the record even after it's been sealed or expunged. But you create the certified copy before you take the action to expunge or seal. Next slide, please. Okay. Sealing is open to a very broad group of people. And I'm going to talk about the different types of records that can be sealed, the process for doing so, and when you can do it. The first step in obtaining record relief is to find out whether or not you have a criminal record. And if you have access to these slides, I've included a number of websites where you can download forms for either seeking to seal or expunge your record, or to find out in the first instance whether you have a record. For those who don't have access to the PowerPoint, you can Google criminal offender record information self-audit request form, and that'll take you to the website. Next slide, please. Okay, most convictions, records of a conviction, of a guilty finding, can be sealed by mail without court action. And let me just make a point about what sealing is. Sealing means that you can answer no criminal record when asked about your criminal record. And it also means that while the record exists, it can only be seen by law enforcement, state and federal, local, state and federal, and it can also be seen by employers, special employers, which is to say people who use employees to work with children, the elderly, the disabled, those kind of special protection people. The employees who work with them are also subject to criminal record checks, and they can see a sealed record. Otherwise, other employers cannot see it, and the public cannot see it. So that's the benefit of sealing a criminal record. Now, to do it by mail without court action, you contact the State Commissioner of Probation office. That's based in Boston. It's the umbrella agency for all the probation offices and all the district and superior courts across the Commonwealth. And they compile and hold criminal records, but they have the power to seal them as well. Now, you can do this over the internet by strike that you do this by mail, but you can download the forms for doing so over the internet. And I've got the website for obtaining that at the bottom of this slide, but if you don't have access to the slide, you can Google petition to seal conviction records form, and that should take you to the form. You should add Massachusetts to that Google request to be sure you get a Massachusetts petition to seal the record. Now, these are the types of records that can be sealed, and there's a time involved for those, for that sealing action. A misdemeanor can be sealed 3 years after you were found guilty or after you've wrapped up your prison or probation time, whichever is later. A felony can be sealed within, or I should say, after 7 years of waiting. And a decriminalized marijuana conviction record can be sealed immediately without the waiting periods for a misdemeanor or a felony. There are some serious offenses that have longer waiting periods or that cannot be sealed. Those offenses are essentially sex and domestic violence offenses. They cannot be sealed. Next slide, please. Now, there are some records which the Commissioner of Probation's office cannot seal, and those have to go before a judge. That includes a no bill returned by a grand jury, which is a failure to indict. Indictments usually involve serious crimes, and grand juries very rarely return no bills, but that's something that can be sealed. A no probable cause finding by a clerk, magistrate, or a court regarding the issuance of a complaint, that is, where someone seeks to issue a criminal complaint and that complaint is denied without a trial, that can be sealed. And finally, a very frequent type of dismissal, any dismissal or a continuous without a finding dismissal, which is a very frequent resolution of a first offense, those can be sealed. And finally, what's called a null pros, which is a decision by the prosecutor not to proceed with a complaint or an indictment. Those can also be sealed. Next slide, please. Now, the criminal conviction record petition can be downloaded from the internet. And if you don't have access to these slides, you can Google Massachusetts petition to seal conviction records form and download that. For a case that ended without a conviction, such as a dismissal or a not guilty finding, that can be pursued. That criminal record can be sealed by Googling Massachusetts petition to seal non-conviction records form. So those are the two forms that you would obtain over the internet and fill them out and then mail them in using the information on the forms. Next slide, please. Okay, when you go to court, and I should say when you file these petitions with the court, for those that require action in the court, I should say when you're seeking simply to have the record sealed by the Commissioner of Probation, if your offense is one that, and the disposition allows that action solely by the Commissioner of Probation, then you don't need to file anything with that except for the information that's required in the petition. You don't have to explain why you need it. You are entitled to have these records sealed as a matter of right. If we could go, slide 8 is where I'm at, Brian. Okay. If you're going into court to seal a record, if you've got a disposition in your case that requires court action that can't be done by the Office of Commissioner of Probation, then you need to, when you file the petition, you need to include some additional information. Uh, you should have your own affidavit stating that you've had some problems because of the record's availability and what the advantages will be to you if the record is sealed. You also should provide some evidence of your rehabilitation since you incurred the record, so that you can say that you've committed no further offenses. You've got a family. You've gotten further education. Things that demonstrate that you've moved on from the person who was convicted or who was charged with the offense. You can provide some information about the offense to minimize its seriousness. And you can also include letters of recommendation from people who know you, who can attest to your good character and that you are at no risk to reoffend. That information will give the judge a basis for sealing your record. Next slide, please. So that's my presentation on record sealing. And just to summarize, it's widely available, and if you've met the waiting period, you are essentially entitled to have your record sealed. Now let's talk about expungement. Expungement is different than sealing. Sealing hides your record from the public, but it's still available for law enforcement and certain employers, as I mentioned. Expungement totally destroys the record. It makes it unavailable to anybody, which is why I always include this warning about getting a certified copy of the record before you expunge it, so that if, despite the expungement, the record comes up again, you can explain what happened. Because once the record is expunged, it no longer exists in any state record agency, so you'll have a tough time explaining what happened without that prior copy of the actual record that was expunged. So let's talk about expungement and who gets it. It's a much narrower range of people who are entitled to get it. There are two types of expungement. The first is age and time-based. The second is reason-based expungement. So I'm going to talk first about age and time-based expungement, both the eligibility for that type of relief and the process for obtaining that relief. So let's talk about eligibility for expungement. First is the offense must have occurred, or I should say the date on which you were charged with the offense must have happened before your 21st birthday. I mean, the purpose of this law is for certain youthful offenders which is primarily people between the ages of 17 and 21, or people with juvenile records. Those are the records that are eligible for age and time-based expungement. Now, not everybody in this age bracket is eligible. To be eligible, you can have no more than two delinquency or youthful offender records. You can have no more than two conviction records, and you can have no more than two conviction records. So that is if you've got three offenses, you are not eligible for expungement. If the offense was a felony, you have to have completed all parts of your sentence 7 years ago, just like for sealing. And similarly, as with sealing, if you've committed a misdemeanor, you have to wait at least 3 years since your sentence was completed to be able to have the offense expunged. Also, you can't have any other criminal appearances since then or pending at the time you seek expungement. And you can't have been guilty of a motor vehicle offense where the penalty is any more than $50. So there are some exclusions to who is eligible despite their age qualification. So next slide, please. Now, there are certain serious offenses which are also excluded, even if you are at age, even if you were younger than 21 when you committed the offenses. If the offense involved death or serious bodily injury, or was committed with the intent to cause such harm, that's not eligible to be expunged. Similarly, offense committed while carrying a dangerous weapon, an offense against an elderly or a disabled person, a sex offense, a sex offense involving a child, uh, a drunk driving offense, or a drugged driving offense can't be expunged. A firearms violation cannot be expunged. A restraining or harassment order or assault on a family member cannot be expunged. And finally, other violent crimes are eliminated from the expungement process. And this to be expunged, even if you meet all of these exclusions and limitations on your eligibility, the judge still has discretion to grant or deny expungement based on what's in the best interest of justice. And I'll talk a little bit more about that. But it's similar to the type of supporting documentation you need for a record sealing that I talked about before. Next slide, please. The expungement process starts with the State Commissioner of Probation's office and getting from that office a petition to expunge form. And again, you can Google that by putting in Massachusetts petition to expunge form. It starts off with the Commissioner of Probation, who has to certify that the record exists and that you are eligible because you don't have any of the disqualifying conditions. This process, like the sealing process, I meant to mention that back in talking about sealing, both sealing and expungement relief are free. Filing these forms, unlike other types of civil remedies, have no filing fee. And but the process starts with the Commissioner of Probation's office. If the Commissioner of Probation determines that the petitioner meets the criteria for obtaining relief, it certifies that you're eligible and lets the DA know. Now, here's a point for seeking expungement, and that is, if you're going to do that, you should contact the DA that prosecuted you, the county prosecutor's office that was involved in the original prosecution of the offense you're seeking to have expunged, to give them a heads up that you are seeking expungement and to let them know that you're not only eligible, but you've got good reasons, which is to say that you had an exemplary life, all of the things that were at issue in the sealing process, to see if you can begin the process of persuading them not to oppose this process. Now, if you're eligible, then there are a very limited number of reasons for the DA to oppose expungement if you are eligible. But it's always a good practice to let the DA know that you're doing this in advance to expedite the process of their deciding whether or not to oppose the petition. Because if they support your petition, that makes it far more likely that, and far more likely that you'll get expungement, and it'll happen more quickly if the DA supports this. They don't have to support it, but it's, I think, a better practice to let them know that you're going to be seeking it, so they won't be surprised when the Commissioner of Probation lets them know that the court is going to be hearing your request for expungement. The DA has the opportunity to object if you're not eligible, or if there's some other reason, and we'll talk about reasons why the DA can object. Next slide, please. Okay, so that I've just described is the age and time-based expungement process. Again, you have to be have committed the offense before you're 21. You can't have more than two priors when you're seeking to have expungement. You can't have committed anything. It's got to be something that happened 7 years ago for a felony or 3 years ago for a misdemeanor, and it can't be certain offenses. That's the age and time-based expungement. I'm now going to talk about reason-based expungement and the process that's involved and the new cannabis record expungement law that takes effect in November. Okay, reason-based expungement involves a request for expungement based on certain reasons. The first is false use of your identification, which would be unauthorized use of your identity or identity theft, which is a criminal record created by fraud, which is for something that you never did. That can be expunged. For offenses that are no longer a crime, such as possession under an ounce of cannabis, that can be expunged. For certain law enforcement errors, and this would be most typically people who were charged with drug offenses during the period of time that the state drug labs in Boston and Amherst were staffed with addicts who were stealing the drugs and filing false findings of illegal drugs while testing the drugs for prosecution. Those types of offenses can be expunged. And so those are the primary reasons. If you fall into one of those very narrow categories of reasons behind your criminal record, you can seek to have those offenses expunged. Next slide, please. Okay, the process it involves this petition for expungement form, which, as I mentioned, you can obtain by Googling Massachusetts petition for expungement form, and you fill it in and mail it into the Office of Commissioner of Probation, and that office does a check to see whether you're eligible. Now, it used to be that, like sealing, expungement could only be done if the judge found that relief would be in the best interest of justice. However, in practice, very few judges granted expungement. Now, earlier this month, the state Supreme Court ruled that if you're eligible for expungement, then the judge should consider that you have a presumption in favor of expungement without you having to prove that expungement will help you in the rest of your life. I mean, I think it's still worthwhile to file the supporting documents. You want the judge to feel good about it, but unless the prosecution comes up with a valid reason for objecting to expungement, the top appellate court has instructed trial judges that they essentially must grant expungement unless the trial judge decides that the reasons for keeping the record outweigh the benefits of removing the record. Next slide, please. Now, the only reason why a judge can deny a reason-based expungement petition is the prosecutor proving or producing evidence that there's a significant or a substantial countervailing concern. If the prosecutor fails to produce that evidence, expungement must be allowed. The types of countervailing concerns are that the primary countervailing concern is that the destruction of the record could hinder an ongoing law enforcement investigation. That type of a reason arises most frequently where there are co-defendants involved with the record to be expunged. But the appellate court has made clear to trial judges that even if the prosecution produces evidence that there's an ongoing law enforcement investigation involving the charge to be expunged, the judge can still order expungement by redacting the criminal offender information, which is simply removing your name from all the other records in the case, so that the record remains, but your information regarding that record is removed. So that is an important benefit to counter a prosecution objection to expungement. You can argue to the judge that simply having your information removed will still allow the investigation to continue against people who aren't eligible for the expungement. Next slide, please. As of November, there will be a new law taking effect that allows people with cannabis criminal records, other than for distribution of cannabis or illegal or another illegal drug to a minor, to file a petition for expungement with an entitlement to relief, such that there is no basis for a prosecutor to make a countervailing concern, objection, or the interference with a law enforcement investigation. The petition must be allowed if you are eligible for this relief. And this takes away the court's discretion to deny expungement of a marijuana criminal record. But again, if you find the judge balking, you can always argue that the record should, the record that the judge, that the DA is objecting to, can simply be changed by having all record information that has your name on it expunged, removed, deleted from the permanent criminal record. Next slide, please. So that is the end of my presentation on expungement. And for expungement or sealing, you can, if you're eligible for legal services assistance, legal services agencies located across the Commonwealth, primarily civil legal services agencies, can assist you with this record relief. You can also contact the American Civil Liberties Union. They have a project for assisting people with criminal record relief. And you can simply Google assistance with criminal record relief in Massachusetts, and other people, other agencies that assist people with criminal records getting them sealed or expunged will be available to you. Now, let me talk about general employment law for people seeking employment who have criminal records. There's a state law that prohibits discrimination in employment, and it makes unlawful an employer to request from a job applicant information regarding an arrest or criminal disposition that in a case that did not involve a conviction, which is to say, a employer cannot ask about cases that were dismissed or that ended without a conviction. The employer cannot ask about first offenses for misdemeanors such as drunkenness, simple assault, speeding, minor traffic violations, or disturbing the peace. Those are matters that an employer can't ask about. An employer also cannot ask about a misdemeanor conviction that happened more than 5 years prior to the job application. So those are protections that you have. And when an employer does a job screening, while at some point in the job screening he can ask about a criminal record other than the records that I've just described, at the first instance, when the employer is screening job applicants for a second round, you can't ask about a criminal record in the first round unless the applicant is applying for a position for which any federal or state law or regulation creates a mandatory or a possible disqualification based on certain criminal offenses. So that is the exception to first round requests for criminal record information under the general law that applies to people applying for any type of private employment. Next slide, please. Okay, I'm going to finish the presentation with describing employment for employment or license applications for people with criminal records in the Massachusetts cannabis industry. And that involves two types of applications within the industry. And this is and these applications are screened by the state agency that oversees the cannabis industry, the Cannabis Control Commission. If you're seeking a license to operate one of a cannabis facility, such as a cultivation site, a manufacturing site, a retail site, or a delivery business, or a testing facility, to obtain a license to own and operate such a facility, you need a criminal record check and by the state CCC, by this Cannabis Control Commission. If you're seeking employment with a licensed operation, one of those types of licenses, then an employee also has to be licensed to be able to be an employee. And those applicants need to go through a criminal record check. Now, I will say that to obtain a license to own one of these facilities, a prior conviction solely for a marijuana-related offense or for a marijuana-related offense does not disqualify you for eligibility to receive a license. Certain types of marijuana offenses can possibly disqualify you, but it's not a mandatory disqualification to own a license. To be an employee, you cannot be disqualified from being licensed to be an employee of one of these facilities unless the offense involved the distribution of a controlled substance, including marijuana, to a minor. Testing lab employees, however, may be disqualified for having any type of criminal record. Next slide, please. Now, under a current law, which is going to be changed in November, a criminal record can be either mandatory disqualifying for being able to work at a marijuana facility or to own a license, or there are certain other offenses which are presumptively disqualifying. The slide shows the offenses involved. There's that make you either prohibit you from having a license or being employed, or that are presumptively making you unable to get licensed or employed. Mandatory disqualifications involves any active pending case, someone who's required to register as a sex offender, someone who has a felony gun charge, and other in the distribution of any drug to a minor, even if it was dismissed after a probationary period. And crimes of violence, theft or fraud also would mandatorily disqualify you from holding a license as well. Presumptive unsuitability, which is a presumptive ineligibility to have a license or be employed, involve other gun convictions, multiple drunk driving or drugged driving offenses, domestic violence, and violence charges that are dismissed after a probationary period or an outstanding warrant. Now, if you've got a mandatory disqualification offense, that's the end. You're not permitted to get licensed. If you've got a presumptive unsuitability finding, then you can seek to have that reviewed by the agency to see whether you can still be employed or have access to a license. Next slide, please. And I guess we're at the end of the presentation. I would just note that as of November, people who have been employed, people who have a criminal conviction are they may have problems getting a license, but they should not be disqualified from working in the cannabis industry. So that is the end of my presentation, and I hope you found it useful. This last page has some information on sealing. If you can get to it, it'll help you in your process.
Thank you, Michael. Excellent job. We are so fortunate to have your experience and expertise in this very important subject matter. This concludes Silver Therapeutics 2022 Virtual Expungement Clinic recording. I want to thank Michael Cutler for his tireless efforts regarding the subject matter. Peace to all. Thank you again.